Thank you so much, Tyrell. And with me in Studio 5, I do, of course, have Allan Lesesa. And we're going to be chatting a bit more about spousal maintenance and legal fees in terms of court rules. Now, of course, this insert is proudly brought to you with the compliments of Neumann van Rooyen. Allan, thank you so much for joining us in studio.
Thank you for having me.
So today we're going to obviously be chatting about something that I feel many of our radio friends have been going through or possibly can in the future. What are the matrimonial matters and their common backgrounds?
Okay, matrimonial matters refer to all issues surrounding marriage. It can be maintenance, children's custody, and so forth. Normally, you would find that the arrangement in many marriages would be that one spouse will decide that one of them would work and the other one will be a homemaker, investing their time taking care of the family and household. And in such arrangements, the economically active spouse will support the other. And this is normally ideal while things are still fine between the couples. But on the flip side of things, such arrangements often leave the other spouse, who is financially dependent on the other, with a dilemma because the economic costs of divorce tend to fare more heavily on the less financially secure spouse. And what happens is that this will result that the spouse experiencing financial hardships due to loss of access to the household income and thus lower or even poor living standards. And echoed in this is the common saying that criminal lawyers would see people at their best and divorce lawyers would see good people at their worst. Some then decide that they cannot afford to defend their divorces because they cannot afford a lawyer or decent living. It is on this note that as our causa celebre, we should talk about spousal maintenance and litigation costs pending divorce actions.
So what can a person faced with all these issues, what can they do?
Interestingly, both the High Court and the Magistrate Courts have unique and special rules to help spouses during their divorce. A qualifying spouse can apply to court to seek relief in respect of contribution towards their cost of a divorce action, as well as spousal maintenance and so on.
So, Allan, what does that all mean?
Say in the scenario as I just outlined above, a stay-at-home parent wants to or is being divorced, and as a result, they no longer have the same access to the funds or income earned by the financially secure spouse. The law is simply saying, do not feel sorry for yourself, not all hope is lost. You can be entitled to be maintained whilst awaiting the finalization of your divorce, and better yet, the other financially secure spouse may be ordered to pay his or her lawyer as well as your lawyer's fees on instituting or defending the divorce action.
Now, how does one go about on using this provision of the law?
What one should do is approach an attorney, explain your position, your financial status, and the situation underlying your divorce. Whether the other spouse is financially abusing you by withholding funds from you or that you simply do not have enough funds. Also clarify your intent and mandate. What do you want? Be it spousal maintenance pending the divorce or contribution towards your legal costs. Based on your circumstances and reason, the lawyer will draft an application for the court to consider on an urgent basis, and the court will hear such evidence as it considers necessary and then make an order accordingly.
All right, now what are the requirements for such interim relief?
Obviously, cases are different and so are people's circumstances, but as an essential element, a person that approaches the court for an order that they be maintained monthly and or their legal fees be settled has to show the court that he or she is entitled to the relief that they seek from the court. This will depend on the living standards of the couple and their reasonable financial means and needs. It is important to note that there are special claims in law, and the basis is the duty of support that spouses owe to each other. Therefore, it makes sense for one to expect that the pinnacle of the application will be based on the applying spouse's insufficient means and also on whether the other spouse, through a proper financial assessment, can afford to meet the relief sought in part or in totality.
So, Allan, in conclusion, what is the advice that you have for divorcing spouses?
The advice goes out that if you want to institute or defend a divorce action but are not in the financial position, don't fold your hands and feel sorry for yourself due to the lack of financial means. Similarly, divorces can be long and take years to finalize. You should not wait for the divorce to be finalized before you can claim maintenance from your spouse, either for yourself or your children. And as a spouse, there are legal remedies available to you to avert financial abuse and prejudice. Use the law to uphold your best interests.
And there we have it. Allan, thank you so much for joining us in studio.
Thank you for having me.
And also remember, if you would like some more information, you can visit nvrlaw.co.za. And of course, this insert was brought to you with the compliments of Neumann van Rooyen attorneys. Tyrell, back to you in Studio 3.
Bye.